Then I'm going to go on to this question, please, as it suggested that Parliament was not a suitable place to pronounce upon it, as Parliament did in the Titulus Regius.
Parliament at that time did, in a sense, pronounce, or rather confirm or ratify, the individual king who was displacing another, that individual king's own personal claim to the throne, usually based in some way or other on the normal means of access to the throne. Parliament just agreed, fundamentally.
How far was Parliament a free Parliament in regard to its relationship with the king? Could the king dictate to Parliament? It wasn't the Parliament of 1984, was it?
It would accept, in this instance, what the king told it, yes.
Yes, thank you.
As indeed it had done with all the other
Yes.
kings who had displaced others in the 15th century.
Indeed, there was a petition from Parliament to Richard to take the crown prior to his coronation. Not Parliament as assembled, because not all the members were there.
The Three Estates, it was called.
Then the other matter I'd like to ask you about, if I may please, is simply this, relating to the pre-contract. It is said by Dr. Starkey that once proclamation had been made of Edward the Prince as King Edward V, then all questions of illegitimacy would have been wiped out. Do you agree with that view?
Well, I think it's true of Dr. Starkey's period, but he's forgetting the reign of Henry VIII and the great increase of the theory of the absolute king. So the situation is entirely different in 1483.
What, in your view, would have had to have happened for illegitimacy like this to have been wiped out? Coronation itself?
Yes, the act of recognition, the act of anointing, and the act of coronation in that order.
Well, now, the act of recognition is when the Archbishop, having crowned, anointed, given the orb and the sceptre, I think, calls upon the lords assembled.
Yes, it in fact precedes all of the other, the other ceremonies.
Right. And is part of the coronation service which survives even to today.
Yes.
Thank you very much. Just stay there.
Miss Sutton, in relation to the pre-contract itself, that was done with indecent haste, wasn't it?
How do you mean?
Well, I mean this. Prince Richard was removed from sanctuary on the 16th of June upon the basis that he was going to attend his elder brother, the King's, coronation a few days later. Within 5 days of that, or 6 days, I think it was the 22nd of June, Dr. Shaw was preaching the bastardization of the princes from the pulpit at St. Paul's Cross.
What is indecently hurried about that?
Well, Miss Sutton, it came very quickly. If at one moment the prince was to be crowned king, and the next moment, out of the blue, it said they are bastards upon the word of Bishop Stillington.
Yes, that's how it happened. I don't think one can argue with that, but
and because of the indecent hurry, it was accepted, and it did not go through the normal process of the courts, did it?
They didn't have an ecclesiastical court.
Precisely.
No.
And strictly speaking, I think I quote you from your evidence in chief, strictly speaking, that is what should have happened.
You could equally argue that an ecclesiastical court on the canonical legal evidence would have had to have found for Richard.
Well, you can argue that, but the whole point is, Miss Sutton, that the ecclesiastical court was never given the opportunity so to do. That's the fact, isn't it?
No, yes, you're into the realm of political expediency.
No,
now.
I'm not, with the greatest respect, into the realm of political expediency. I'm into the realm of the law. The law at that time said that the ecclesiastical court should have resolved the question as to whether or not there was a proved pre-contract, and that would have meant Stillington giving evidence and being examined upon it. And that never happened, did it?
No, not at that point.
What happened was that it was presented to the Lords at that time, the Lords not in Parliament, but the Lords in an assembly in London, to which they had come from various parts of the country for the coronation.
Yes.
And it didn't come before Parliament until the following January, did it?
No.
And do you accept or not what Mancini said about this? And that was the only reason why the Lords accepted it, was because they'd seen what happened to Hastings, they'd seen the unholy alliance between Richard and Buckingham, they had realised that the multitude of troops from the north were at the gates of London, and they were frightened.
They were intimidated. Do you agree with that?
That's one way of looking at it, but it doesn't alter the fact that the pre-contract was a valid moral reason for Richard to take the throne.
If it was a valid pre-contract, but that begs the question, doesn't it, Miss Sutton? I'm suggesting to you that Dr. Pollard is right when he says the pre-contract was in fact a trumped-up pretext and trumped up in haste over a few days.
Yes, I don't believe it was trumped up.
You described it indeed as the crux of the matter.
Yes.
Why do you say that?
Because it gave Richard a genuine claim to the throne, a moral claim to the throne, as well as the political reasons to make him secure.
And the evidence of Stillington, and it was only upon the evidence of Stillington, wasn't it?
Oh, yes.
Yes. It came at a very opportune moment, at the very time that he wanted an excuse to take the crown.
May I ask, how came it that Stillington took this upon himself to make this pronouncement?
He was a canon lawyer. He could make the connection
I see.
between the fact of the pre-contract and the clandestine second marriage.
Miss Sutton, am I not right in saying that the suggestion was that Stillington had been the witness to the pre-contract?
There is that suggestion that
I'm not
could be
suggesting
so
it's necessarily true, but in answer
No,
to what His
it isn't.
Lordship says, I think there is a suggestion, I forget now where it comes, but that Stillington was the person who was the witness to the pre-contract, and only he and Eleanor Butler and Edward IV knew about it, and the other two parties, Eleanor and Edward IV, by then were dead.
That is found, yes.
So here was a one witness to say this about something which silence had been kept over a period of what, 15 years?
In canon law, you didn't need more than that, because you acted on the presumption of truth.
It might have been very suspect there. And indeed, as I suggest, it is.
If people generally accepted it to be true, that was more important than any evidence that could be presented in a court of law under canon law as they understood it.
But the
then.
difficulty was, of course, that people didn't generally believe it was true, and we get that from Mancini as well, don't we? The corrupt preachers and the colour for the usurpation from Croyland.
That's only one chronicler.
Anne Croyland,
Two
the colour of the usurpation, and Mancini makes it clear that the general belief at the time was that this was not a true contract.
Yes, it's still the words of two men.
Better than the word of one, Miss Sutton, Bishop Stillington. At all events, if we face this practically, did it really matter in any event? Because the fact that there may have been a pre-contract, the fact that the children may have been bastards, that could so easily have been reversed by Parliament, and indeed was.
It could have been.
But you see, Miss Sutton, this is the point. As I understand it, what is being said on the defendant's behalf is this. There was a pre-contract, it did bastardize the princes, therefore Richard had a true claim to the throne, and therefore he had no need to kill them. That's what
Exactly.
I understand the suggestion to be.
Exactly.
But the fact of the matter is, whether or not that was a valid pre-contact, he had every reason to have them disposed of, because Parliament at any time could have reversed that illegitimacy, as Henry VII did 2 years later when he came to the throne.
I don't agree.
Well, but why don't you agree? Parliament could have, and did.